Hi, everyone. My name is Mark McKenna. I'm a faculty member in the law school and the director of the Notre Dame Technology Ethics Center. I'll be moderating today, and I'm joined on the panel by a distinguished group of experts. We're just going to introduce quickly, and then we'll turn it over to each of them for some introductory remarks. First is Dr. Kirsten Martin, who's the William P. and Hazel B. White Center Professor of Technology Ethics and Professor of Information Technology, Analytics, and Operations in the Mendoza College of Business at the University of Notre Dame. Dr. Martin researches privacy, technology, and corporate responsibility, and she's also an affiliate of the Northeastern University Center for Law, Innovation, and Creativity, and a member of the advisory board for the Future of Privacy Forum. She's a recent book with Ed Freeman and Bobby Parmer called The Logic of And, Responsible Business Without Trade-Offs. Dr. Eoin O'Dell is Associate Professor of Law at Trinity College, Dublin, where he researches and publishes primarily in private and commercial law with a particular emphasis on privacy. He's also been president of the Irish Association of Law Teachers and editor of the Dublin University Law Journal. And finally, Deen Kaplan is a leading international trade and cybersecurity practitioner who's widely recognized for guiding clients through complex multinational legal and technical challenges. Mr. Kaplan represents businesses and governments in some of their most demanding international trade and investment disputes, cybersecurity matters, and cyber policy related issues. He also serves as a global director of the firm's international trade and investment practice and co-head of Hogan Lovells cyber risk services. So the way we're going to operate this panel is that the title of the symposium is Privacy in the Age of Surveillance, the Good, the Bad, and the Ugly. And this panel is focused on the bad. So in particular, we're going to be focusing on the costs of surveillance, loss of privacy, lack of protection for personal data, loss of anonymity, and probably several others that will come up. Each of our panelists is going to have about 10 or 15 minutes for some opening remarks that are on the theme. And then we'll have a moderated question and answer period, which I will moderate. But please feel free to send in questions for any of the panelists. Those are coming straight to me, so I'm happy to incorporate them in the conversation. So Kirsten, would you like to go first?
Great, thank you very much, Mark. And thanks for having us here. I have a few slides to show just to kind of organize my thoughts on this. So, and what I want to talk about is, and hopefully broaden the idea of what types of corporations are actually involved in surveillance and the harm that surveillance does of individuals. And by doing so, I'm going to rely on two different people that talk about surveillance. So one is David Lyon, who's kind of a famous surveillance scholar. And he talks about like the two prongs of surveillance required. So the accumulation of information about individuals, but then that also not only accumulating that, but the information, but then using it to then control, supervise, manipulate those individuals. So we usually think about this, and he relies on Foucault's the panopticon, but this idea of a centralized data collection, either by an individual or by technology. But then also important to that is that it's then used to control those individuals. And then layering on top of that, Julie Cohen, who's a privacy scholar at Georgetown, talks about surveilled spaces as having a twofold disability, which I think is helpful, that the targets of surveillance cannot entirely avoid the gaze. So this is important to the understanding surveillance. And also the targets cannot necessarily identify the watchers. So there's something different about surveilled spaces and surveilled individuals in that not only are they being surveilled or watched, but there's this feeling of not being able to get outside of the being watched, outside of that space, and then also not being able to see who's watching. So you never know when you're being watched. So I'm going to use these kind of four prongs of surveillance to talk about when we might see companies actually contributing to surveillance. And I think these are companies that don't think of themselves necessarily as a part of the surveillance state. And so it's important to know that surveillance is a tool not only to know information, but to control them and alters the balance of power. So for Cohen, the idea of power imbalance is really important. This idea of an unseen, knowing being or technology or centralized government or corporation watching changes that balance of power. Okay, so who would we see corporations, how would we see corporations being involved? I'm going to say there's two different ways. One is as an arm of the state. So there's a lot of work about how data collectors, trackers on phones and apps and websites, data aggregators are used by state actors to identify people that they don't like what they're doing or try to understand what they're doing. But then second, as a part of the private surveillance apparatus. So this is just all within private companies and the fact that we feel surveilled even when the state's not involved. Okay, so first, as an arm of the state, we see firms in the turquoise gathering data about us, where the state is then able to gather the intimate knowledge about us with the proximity to us, because they're the state, to manipulate us either through covert campaigns or actually to control us perhaps through arrest. So this could be the intimate knowledge gained from us from being watched online, location data aggregators that will know where we are. And in this way, firms, I would say, play three roles in the surveillance state. One is the mere accumulation of knowledge. So when we have firms that through CCTV or license plate readers or facial recognition or trackers online or location data aggregators, when they are just accumulating data, that's the information, that's a key part of surveillance. Second, if they create a situation where we're not able to get out of it, so the idea that we can't use our phone without our location being tracked, or if they are a part of a system where us going online requires us being tracked, they are contributing to part three, which is targets not being able to identify or avoid the gaze. And then finally, they're actually involved in the idea that we can't identify the watchers by being hidden. So when corporations make that decision to remain hidden, and though individuals don't know when they're being tracked, they're contributing to actually an important piece of surveillance, whether they know that or not. And I would say that they need to be held responsible for that role. So the only part that they're actually getting out of in being an arm of the state is the direct supervision or control, because they are not the arm that actually does that, right? That's the state that does it at that point. But it would be a mistake to actually say that corporations aren't a part of that surveillance state, because they're doing 3 of the 4 required pieces of surveillance, according to Cohen and Lyons, when it comes to the idea of a surveilled space. So second, one was as an arm of the state, but second is just as this part of this private surveillance where, the idea of surveillance capitalism, the idea of this data ecosystem, where all of these firms, these data aggregators and different types of Facebook and social network sites have this intimate knowledge with us, and importantly, also have that power to manipulate us. So the ability to target us with disinformation campaigns or ad networks being used to kind of steer us and our votes in a certain way. It might be that they're able to manipulate and target advertise to us. So they have both arms of it. So they not only have the capabilities and contribute to surveillance through the accumulation of information, us not being able to avoid the gaze, and being not able to identify the watchers, but they then have the final step of it, which is the direct supervision of the individual with the ad networks that are able to then target us individually. And so I think what this does is actually broaden the companies that we think of as being part of surveillance. What we usually think of them as something that's perhaps like Facebook or social network sites, where they have all of those pieces all together at the same time. But it's important to know that firms can contribute to the surveillance state in a way and be held responsible for how they are a part of a larger network. So we regularly hold companies responsible for pollution that contributes to global warming. They're not causing all of global warming, but they are a major part of it, and we hold them responsible for that. We hold Nike responsible for how their suppliers actually created their products and if they have unfair labor conditions. So this idea of being a part and being held responsible for the network of what your entire network does is not novel to businesses, and we need to start thinking about firms as actually being major contributors to the surveillance state. Okay, so in sum, I said that companies have 2 different roles. One was as an arm of the state, and second, as their own private surveillance network. And that there are 4 major portions of surveillance, and it's a mistake to think that someone has to do all 4 of them to be a contributor to surveillance. That a company could do any one of these 4 and be a contributor to surveillance. And we need to talk about the responsibility of companies of possibly, if they're accumulating information, to not make it so that we can't avoid them and not make it so that they're hidden. Because in making those 2 other decisions, they're actually making the surveillance state and the feeling as a surveillance state even worse. And that we need to start talking about surveillance as this balance of power, or this imbalance of power that kind of shifts control to the people who are all knowing. And I would like to add that these last 2 pieces of not being able to avoid the gaze and not being able to identify the watchers, not only are they key for Cohen in creating a surveilled public space and violations of privacy, but they also are key so that we cannot actually have market governance over these actors, these firms. So there's no natural way that we can say, please stop tracking us and please stop surveilling us. Like if I use this example with my students all the time, but when we don't like fries at McDonald's, we just go to Burger King, and there's this direct relationship between the consumer and the firm doing us, quote, harm. When we have these actors that are unavoidable but yet hidden, that actually makes it so that we can't even, through a market mechanism, pull back our data and actually avoid them. So it makes it so that there's no natural force for these firms to actually stop surveilling us. So not only are they contributing to surveillance, but they're actually making it harder for us to say no at the same time. So that's it. That's why corporations should be held responsible for their role in surveillance.
Great, thank you. Eoin?
Thank you very much indeed. I'm going to start by thanking everybody for the invitation. Thank you to the Journal in particular, and hopefully we'll get to do this all in the real world in South Bend next year, as opposed to remotely. Now, I'm going to make 4 basic points, and Kirsten has scarily made my second one much more scarily than I could. So, thank you for that. I'm terrified. Okay, I'm going to start in a happy place. I'm going to start in literally the happy place. I'm going to start in Utopia. Now, Utopia is a novel by Thomas More, who is a 16th century English philosopher and lawyer. He was Lord Chancellor for Henry VIII. He refused to accept Henry VIII as the head of the Church of England, and he was executed, and he was made a saint by the Catholic Church for his troubles. But what I want to talk about is his book, Utopia. And the title comes from you meaning no, and topia meaning place. So he wrote about a perfect society, and the title of the perfect society was that it couldn't exist. But by the 18th century, the title had changed slightly, or the understanding of the title had changed slightly. You in ancient Greek also meant good. And so Utopia was understood as a good place. And then in the 19th century, an English political philosopher called John Stuart Mill, who along with Bentham created some of the stuff that Foucault was reacting against, that Kirsten was referring to, talked about a horrible place, a dystopia, the bad place. And this is the panel about bad. So I want to focus on the dis part of that. And we're all familiar with dystopia as a description in fiction, for example, of when the state goes wrong. And one strand of dystopian fiction is pervasive state surveillance. The classic is Big Brother in Orwell's 1984. And it's, just put dystopia and NSA into a search engine, and the number of examples that will come back is legion. But my point is that, we have dystopia as a word to describe when the state goes wrong, and in particular, when it goes wrong by pervasive surveillance. But as Kirsten described, we also have private surveillance. Surveillance is the business model of the internet. This is a phrase from Bruce Schneier, but explained very well and in scary terms by Kirsten. And Zuboff has told us that it's a whole new breed of capitalism. It's surveillance capitalism. And again, if you put surveillance capitalism into a search engine, you'll be told that it is leading towards a dystopia. That the death of privacy from surveillance capitalism is leading towards a dystopia. But I don't think dystopia is the right word when we're talking about surveillance by corporations rather than surveillance by the state. It's not topos. It's not a bad state. It's a bad corporation. And it's bad social surveillance rather than state surveillance. And there's another Greek word for a social group. It's agoria. It's very close to agora, the place where you come and discuss. And I think we should think about surveillance capitalism as not dystopian, but dysagorian. An example of the kind of surveillance capitalism that we're talking about is Dave Eggers' The Circle. It's a terrible book. It's an even worse movie. I've read the book and I've seen the movie, so you don't have to. The problem is I ordered the book from Amazon and I watched the movie on Netflix, and now I keep getting pitched terrible books and terrible movies by Amazon, in a perfect example of the kind of advertising surveillance that Kirsten was talking about, targeted ads being the means by which the internet surveils and responds to the surveillance. But this Netflix, Amazon, Facebook, Google, Apple surveillance is not dystopian, it's Disagurian. And I think it's important that we draw that distinction, that we use different words to describe the different kinds of surveillance. If we can name it properly, we can describe it properly, we can understand it properly, and we can address it properly. Currently, a lot of our language and a lot of our intuitions about surveillance and the problems of surveillance and privacy as a response to surveillance are shaped by the state versus individual context, or state by dystopian assumptions. I love Julie Cohen's work. I think the way in which she engages with the problems of surveillance and uses privacy as a response are fantastic. And drawing the analogies between the state and the private, very important. But privacy works as a response when the surveillance is still concerned with the individual. State surveillance, the NSA wants to get the bad guy. They want to arrest somebody. They're still thinking about an individual, and the Fourth Amendment and the tort of privacy are individual responses. So privacy is a good response to dystopia. But this kind of individual privacy is not a good response to Disaguria. It's not a good response to the situation where the invasion of privacy or the problems are corporate surveillance, because it's a very different surveillance. It's not surveillance of individuals. In these circumstances, the state-centered dystopian language and intuitions are less helpful. It's aggregated data that the big companies want. It's a relational sense of how we relate with others rather than just who we are individually. And this requires different responses, a very different view of privacy. Privacy is a relational rather than an individual thing. And it requires very different legal responses too, legal remedies too. It requires not just a private cause of action, but class actions. Because it's as a class that the harm occurs. And the recent decision of, the 11th Circuit that says that the individual in a data breach doesn't suffer any loss is because it's not loss as an individual, it's loss in a relationship with others. We need structural responses. If you want to get at the oil companies, you turn off the oil. You tell them they can't pump and they can't sell it. If you want to get at the data companies, you have to stop them processing the data unlawfully or unfairly or scarily. And you may need market structural responses. If we have individual market failure, where the market can't respond, you may need antitrust or competition responses. And finally, because these are problems that are by multinationals, you need multinational responses. You need to control or perhaps prevent international data flows. If you can't transfer all the data back to Menlo Park, if you happen to be a company that has a corporation headquarters in Menlo Park, may not be able to pump the oil. So, for example, the data adequacy decisions between the EU and the US, we had another one between the EU and the UK today. And again, you need to ensure that those kinds of data flows are controlled. So, two things. First, the takeaway is when we start doing what Kirsten says and thinking seriously about the consequences of private surveillance rather than state surveillance, we have to change our language accordingly. And secondly, I finished with examples of international data flows, which is where I understand Deen comes in. Thank you very much.
Great, thanks. Over to you, Deen. I think you're muted still, Deen.
Unmuting now. Didn't want to cough while my colleagues were saying it. So thanks to Kirsten and thanks to Eoin and to you. Couple introductory remarks and then 7 propositions, which I'll pop up on a slide just so that they're a little more memorable than my voice. The introductory comments, beyond good to be with you, is you've got a series of scholars here, basically everybody on this panel with the exception of me. I'm a practitioner and I spend most of my time dealing with privacy or dealing with surveillance or dealing with data theft in the context of very specific examples where either a person or an entity has been harmed and they're looking for some sort of either protection or legal redress from that. So as a function of that, what I'm going to try to do here is just lay out in the introductory piece a few of the propositions that I have consistently seen with respect to privacy in the age of surveillance, and as Mark guided us, what we'll call the quote unquote bad, or why don't we say challenging piece of that. Let me put up my 7 propositions and I'll speak to each in a sentence or 2 if I get them up. Kirsten was much better prepared on this front than me. All right, is that up there? Mark, I think I saw you nod.
Yeah, you're good. Yep.
Okay, good. Proposition 1 that we see again and again and again in my practice, the declining cost of data permanence. For the present generation, I don't think many people realize just how much of a change this is from even 20 or 30 years ago. In order for data to have value, it has to be reviewed. In order for it to be reviewed, it has to be stored. In order for it to be stored, there has to be a means to do that, and that means has to be cost effective. Nobody's going to do this just for the heck of it on a broad basis. We have seen data storage decline exponentially in terms of the difficulty of keeping lots of data for a long period of time. And that has enormous implications for surveillance and enormous implications for privacy. Again and again and again, there's a time value to data. So if I'm doing a deal and I'm negotiating the final price of the deal, knowing what I might offer an hour before the deal is closed is a lot more valuable than knowing what that number was an hour after the deal has closed. So you can see there's a time value. The longer I can keep data and the larger the volume of it, the more I can surveil basically everything. Proposition 2, right along with the low cost of data permanence, the increasing speed of our connected world. Again, in the modern world, from what I've seen, most clients and folks take that for granted now, but you can look back 10 years ago or 20 years ago or 30 years ago, when we first started to see a development of the internet and we first started to see that connectedness. Even then, with the connectedness, it was a limited world, and the speed of sending large amounts of data around that world made it difficult to aggregate data in a way that you could effectively surveil. Things we take for granted now, streaming and other things that enrich our lives in the good, because we can basically pop up anything on the TV. The video piece of that didn't even exist. And of course, that has tremendous implications for surveillance too. If I've got millions of cameras up in places around the world, they can easily transfer that data from point A to B or C, D, and E, then that makes it that much easier for a party to invade privacy and to surveil in a not good way. Third proposition. Boy, do we see this in practice. The incentives to track are high. I always use the espionage example, although it's mixed in terms of the privacy world. Option A, you develop a source as a state. You want to get intelligence. You're going to have to carefully cultivate that source. If you're in another country, you're going to be tracked and people are going to be watching what you're doing. If you want to get information from that source, you're going to have a Dropbox or figure out a way to meet. This is the old world. Go back and read the John le Carré novels and the other pieces that are out there in terms of how this operated. In the present world, if I can go online and I can get that data in a matter of minutes, and I never need to leave my business office thousands of miles away, the difference there is, again, a quantum difference. And so you have to be honest with yourself and say whether you're a corporation, and we can get into several areas of discussion there, or you're a state, or even in some instances, if you're an individual, you're highly, highly incentivized to track data, because it's generally an easier way of getting what you want, including when you have a nefarious objective, than the old methods that existed before the internet as we know it now. That leads to the next proposition, a quantum leap over previous generations. When I started out on the internet, I was a member of CompuServe. I had a little 14.4 K modem, wouldn't stream 15 seconds of video that we can see on any TV now. And so again, there, you've got to know that where we are now in a fundamentally different way is fundamentally different than where we've been. And that has the implications that we're here to talk about today. Fifth proposition, anonymity is gone. I suppose you can maintain some sense of anonymity if you are willing to shut yourself completely off from the online world. And by that, as Kirsten highlighted and others, a cell phone, basically anything. We can talk about that more. But if you want anything online, you have no reasonable prospect, from what I see practicing in this area day by day, hour by hour, of anything that approaches the anonymity that you could have as an individual even 20 years ago. Sixth proposition, surveillance is regularized, both the state, and by state I mean governments, and also on a corporate basis. This goes back to the incentives to track are high. I have been in surveillance situations and literally watched state actors get up, enter the office to track various companies or various individuals, track those individuals over the course of the business day. You can watch the tick in the activity go down as they take a break for lunch. And then as soon as lunch is over, you can watch the activity go back up. There are whole desks on governments that target particular companies or particular individuals, where the job is to day by day keep an eye on what is going on with that individual or that company electronically. And I've seen that personally with my own eyes in numerous client situations. And so you're regularized there in it is a scary way when you see some of what goes over the transom there. In the same sense, corporations are incentivized the same way. If you're going to get sued for an employee harassing somebody or not having sufficient controls, the ability to put in an electronic control that watches what they do on their network and creates an automatic alert and keeps that liability away from you and on that misbehaving employee is an incentive that you're going to pay attention to as you evaluate how much privacy you're going to have on your network. And then the last piece, and we're over to Mark to guide us in the good questions that come. We think of data as private, and I'll just say to you, as a practicing lawyer in this area, most private data can be effectively requested by legal process, and they don't need to request it from you. You have records of everything that you do around the world. And if a government wants to subpoena it from Google, or they want to look at your iCloud account, or in many instances, one corporation wants to check on something via another, there's going to be a legal process that's going to create a means to do that if they have a need for that data and there's a reasonable legal basis for it on an investigation. So this goes back to anonymity is gone. What you may think of as private day by day isn't private as all. I'll close by saying that's a bad thing, but that can also be a good thing. If you've got a child abuser or someone trafficking in other human beings, and you can track that data and provide absolute proof of it, it's an ability to catch somebody that you want to catch. But there are many ways that that also plays out in a potentially very negative way as well. With that done, I think within our 10 minutes each, and back to you, Mark, and look forward to the dialogue. And I will unshare.
Okay, great. That was a really great set of introductory remarks. They did a lot of good framing for us. We're already getting lots of questions coming in, and I have some too, but I also just want to invite you all to, sort of react to each other. And so don't feel like this needs to be just me asking you questions. If you all want to engage with each other, you should feel free to do that. One thing I guess I wanted to start with, because it was a question I sort of had coming into this, is about what we mean by the word surveillance and about sort of the nature of the harms that are involved. And so Kirsten did a really nice job, I think, giving us a framework to think about that. But all of you in some way or another touched on this, which is that I think there's sort of a couple of different dimensions of the shift that all of you described. One of which is that, back when I was in law school, if you were talking about surveillance, you almost certainly were thinking about government surveillance. You were thinking about government activity. So one dimension of this shift is the sort of shift to thinking about private entities as being engaged in surveillance, right? The age of surveillance capitalism kind of idea. But the other one is the one that Eoin in particular mentioned a lot, which is this sort of shift from thinking about privacy in sort of individual terms to sort of relational terms, maybe connected to the idea that this data is sort of most important, at least to companies, when it's aggregated or when it's sort of sorted in that way. And I guess I want to sort of think about the meaning of the word surveillance, as Eoin sort of invited us to, and what kind of harms we have in mind if we're thinking about the government versus private individuals. Like what are the harms that we're worried about to individuals if it's a private entity that's surveilling them, and if it's not specifically their information that anyone cares about? Like what are we worried about in that circumstance? I've stumped you. Yeah.
Well, I'll go. So, I think sometimes we could point, the state's easier to point to like actual harms, because you're usually talking about a state coming and arresting somebody or taking some sort of state action. So I think the harm of the repercussions of surveillance are easier to identify with the state. It's harder to wrap our heads around, well, what harm is it if they're manipulating us online or something along those lines? And I think we could talk about that as harm, but it's easier to talk about the harm of the state. I think that Cohen also does a nice job of talking about how it fundamentally changes the space. And there's been other scholars that have talked about that, where you're able to be in a space and like try new things and talk about weird things. And think about if you're having a class discussion and you purposely don't record it, that's just a different, feeling of autonomy and freedom of thought than you have in a space that's constantly where whatever you're doing is being gathered, and furthermore, you don't know what it's going to be used for. So you almost have to think of the worst case scenario. So I think part of the harm is that we have fewer of those spaces where people feel kind of like autonomous, individualized, able to, it's a very Western way of thinking about things, but able to try out and say new things, that type of idea. And that is harmful in the long run, both for the individual, but then for society, because we're better off when we have autonomous people like running around and thinking about new thoughts and, speaking truth to power and all that kind of stuff. So I think that, but I agree, I think the state harm or repercussions of the surveillance, so the control aspect, is easier to grasp in some ways. But the other one's so insidious that we just gently are doing it all the time, that we're constantly aware that what we say or do could be used against us when we're online, or the fact that these location data aggregators have all of our information. and can track not only where we go, but who we're hanging out with, or whether we attended a rally, all of that type of thing. It's actually harder to get out of it. It was easier to avoid the state. It's harder to get out of the commercial surveillance.
2 or 3 agree completely with what Kirsten just said. 2 or 3 things I'll add to that in bullet form. One, the line between interested in you individually and interested in you in an aggregate sense is a very fine line and a variable line. And to the degree you have data permanence, that line can change after the fact and affect human behavior. You go back to, if you're going to keep that data and know everywhere someone went, you may have one purpose at the start and a different one. Second, what I'll call the human freedom slash behavior slash intellectual freedom aspect. And Kirsten touched on this as well. I date myself again in the older sense. I remember a show, Candid Camera, where they'd have a hidden camera. And then at the end of the thing, after whoever was the focus had thoroughly embarrassed themselves, they'd say, "You're on camera." And there would be this crazy, humiliating moment, and everybody would laugh and, "Oh my gosh, I can't believe I said that," et cetera, et cetera. We're on candid camera in many instances all the time, not just by governments, but by private entities. We just don't realize it. And to the degree that that becomes more pervasive, in my view, it will affect human behavior over time. There are several other things I could highlight, but I'll start with those 2.
Okay, I'd like to pick up on what you've both just said. Mark's question, where's the harm? What are the harms? I'm going to give 3 anecdotal examples. One is the line that Target knows you're pregnant before you do. By virtue of the advertising tracking and the change in shopping habits, you might be interested in things that you weren't interested in a couple of months ago, and the explanation for that change is that you're pregnant. I saw a more recent example of that. TikTok was in the headlines a few weeks ago because of all of the sea shanties and the building on them. But another story that I read around the same time, which was, washed away in the sea shanty tsunami, was a woman who said, and this was her headline, "TikTok knew I was bi before I did," by virtue of the increasingly individually refined suggestions that TikTok has, even more refined than Netflix or Amazon that I was complaining about a little while ago. And thirdly, the points from Deen and Kirsten, we can't turn off if we try. There's a New York sociologist who got pregnant and decided to do her pregnancy entirely offline. She wouldn't tell anybody about it on Facebook, Twitter, whatever. She would, in respect of all of the pregnancy things, purchase in cash. If somebody wanted to give her a gift, she wouldn't accept an Amazon delivery. This is pre-pandemic. So she got trading cards. And in the 4th month of the pregnancy, her husband went to a supermarket to buy some stuff and to pay with a supermarket card. And an FBI SWAT team arrested him because by going off grid, they did all the things the bad guys do to trade weapons or trade drugs or whatever. She had made herself, by virtue of the overlap that Kirsten was talking about between state and private surveillance, she stuck out. She had a red flag and she had made herself a target. So that we can have anecdotal examples of individual harms. But I'll go back to my main point. Thinking about individual harm is a function of the 4th Amendment. It's a function of thinking about the state infringement of privacy. When we're thinking about dysauguria, when we're thinking about corporate surveillance, the harms aren't individual, and it's hard to use the word harm when you're thinking about the creepiness that Kirsten described by capitalist surveillance. The problems, I'm not going to call it harm now, I'm going to call it problem. The problems are more relational, more structural, and legally we don't use the word harm for these kinds of things. And that's just an example of how, if we think in terms of privacy in a dystopian fashion, harm is the right word, but if we think in Dysagurian fashion, it isn't.
Yeah, I'm very struck by that. So when I teach privacy, you might say like a meta theme of the class is like constantly going through the fact that all of our sort of sources and origins of ways of thinking about privacy are individual tort actions or constitutional rights, and that and then you spend a lot of the class talking about like people's cases get dismissed because they can't show individualized harm, and then there's all kinds of problems in figuring out this. So it's like a meta thesis on how basically you can't use any of the tools to get at any of the harms you want. So I was just going to give you an anecdote about that too, which I think maybe has also something to do with this, which is about it may be that the people collecting and using the data are only interested in the aggregate, but that means that they sometimes expose people to risks that aren't really, they don't internalize. So I got a notice a week or two ago that there had been a data breach, that my social security number had been exposed in by an entity that I neither had ever heard of or didn't know that I had ever interacted with in any way. So this entity was somehow either a data broker or in between a number of the transactions. So I had never heard of them. If you look them up online, it's like a shadow entity. You can't find anything about it. And I remember, and I had a conversation with about a couple of my other privacy friends. And so I have no idea how this happened. I don't know who it is. And basically there's nothing you can do about it, right? Because what they offer you is credit monitoring for 6 months or something. And that's pretty much it. So it may be the case that this entity actually didn't care about me at all, but precisely because they didn't care about me at all, like the risk that they exposed everybody to, they didn't internalize in any way, right? And actually a whole bunch of the questions that have come in are about data breaches and about whether those are the kinds of things we ought to be concerned about, and sort of like people collecting and using all this data are exposing people to lots of risk that they don't really care about in that way.
So Mark, again, just quick practical example, what I'll call a smash and grab breach, deal with all the time for clients. Credit card can be replaced. So I don't, in my kind of hierarchy of concerns, I changed the number, I'm going to be okay. I've got some risks in terms of credit history and things like that I've got to manage, etc. They grab a medical record at the same time, or they grab a social security number, or they grab FBI interviews of you that are stored in a given place because you needed a security clearance or something like that from the US government. There's a permanence to that data that will never go away. And once they have it, you can't change it. And so back to your point, the intent may have been somewhat aggregated at the start, but the damage ends up being quite personal.
Yeah, that's so another thing that several people have asked about that I want to ask about here is this sort of this concept of Kirsten, you started at the beginning by saying that, one of the challenges, I think you even bracketed the last two, is that because you don't really know who's surveilling you and you don't really, and you really can't get away from them, that they sort of live outside of market forces. So, one set of questions here is sort of like, and maybe also going to Owen's question about how we have to sort of think differently about what the tools are here. Are there ways of reintroducing market forces here? Are there actually solutions that we could say, well, if the problem here is an imbalance, right? People are unable to actually bring market forces to bear on these companies. Are there solutions either in sort of like the way we organize the market, or are there legal solutions that would sort of rebalance those where that could be fixed?
Yeah, so this also picks up on Deen's point that right now companies have no reason to not gather your information. And that is like the flip side of the same coin. So there's every incentive for them to gather your information, even if they don't know what they're going to do with it. So they can get it, they might be able to sell it to somebody else. But there's no cost to that. I mean, unless there's some sort of extra insurance they have to get for data breach, but really the payment on a data breach isn't that high, so it's not, there's no market answer to that. I think if you imagine like water flowing, the way that the water flows into the data ecosystem is through things that we have to interface with, like websites, apps, our phone, our computer, if they're grabbing our IP addresses and tracking us that way. I'm not talking about, let's just bracket location tracking just for the moment. And so one way of not having people that we don't have access to, these third-party data aggregators and ad networks have access to our data, is to like tighten the spigot, right? Like to actually make it so that these customer-facing websites that are the gatekeepers, if you would imagine, to the data ecosystem are held somehow responsible. And this could, I'm at the point now where I thought that there could be a market movement towards companies not allowing trackers on their websites or not in their software development kits for apps. And there are some, like the New York Times has actually moved more to contextual advertising and stopped a lot of tracking, although they still have trackers on their site. But I think that there could be some sort of regulation that actually made companies that are customer facing actually responsible to having upfront, like, these are the trackers that we allow on our site to gather this type of information from you. And if there was that type of, not mere notification, but then whatever then happens to your data, that the customer facing company is actually responsible for that. So the example that I would give is universities are responsible for who they bring in career services. You know, the companies, if Ford comes in, if, you know, Eli Lilly comes in at Notre Dame, because we have these students and we hold them, quote, hostage. And then we bring in people to interview with them. And we take responsibility for that. Like, we vet them, we make sure they're kosher, they're okay, and then we bring them in. And so it's not that different than having a website being responsible for their users and allowing who comes in and actually surveils them, right? And so it's not, we do this with companies all the time, that we hold them responsible for the third parties they bring in. And so I think that that's one way, is making, but you have to move it to the edge, you know, so you could do something on the data aggregators, but a lot of it would have to go to the edge, and that would be more of the edge, meaning customer facing. That would allow the customers to actually choose which companies they want to deal with based on the number of types of trackers that they have on their site. I mean, even if they just had to say it like they do in SEC filings, I think that they would be held more responsible. But that would be a joint market / regulation, is that you regulate the people who are more edge at the customer level, if that makes sense.
Careful what you wish for, Kirsten. This is exactly happening just right now in the European Union. If you think the GDPR made life difficult online, the e-privacy regulation, which was meant to be adopted in parallel, but which was bogged down in 4 additional years worth of lobbying, has just been the second last legislative stage was jumped last week. And this is the real driver of cookie banners. This is the real driver of disclosure of the way in which cookies are happening, and therefore the way in which data for that reason is being shared. And it's a mess. We're getting horrible cookie banners. The cookies are divided into all sorts of different categories. You dig into who the data is shared with and why it's shared and so on, and you just simply discover banks of information and banks of the sorts of people that Mark was talking about, that between you and the company that you want to talk to, there are several hundred other participants in the ad market. And it makes very little difference. People just either agree to all of the cookies or try and engage and discover that it really is impractical. So that regulation, we've already had a directive. It wasn't particularly strong. The European Commission wanted to strengthen it. The pushback was enormous by big data companies. The compromise is awkward. The reality is a mess. So I'm not sure that that kind of regulatory response is going to be hard to get in a US environment where you don't have federal privacy legislation. All of the various state responses are less comprehensive than the GDPR. I can't see any privacy cookie type response happening in the US anytime soon. And even if it does, you know, if it's as compromised as the EU one, it's not going to be great. I think the more structural responses, the antitrust response, the control of data flows response, the idea of not just individual claims, but class actions, these are the kinds of things that are likely to make a greater difference.
If I could just qualify, I don't believe in notification. What you just described as notification issues, and I don't believe in that. So I just sort of make sure, I don't think notification and better notification works at all. It would be, I just checked, the Washington Post has 53 trackers on its website. There's no way it knows how that data is flowing. So I think that the Washington Post should be responsible for how consumers' data is used that they sold to these trackers. So if there's any instance of any manipulation or harm or privacy violation or breach down the line, that the Washington Post would be liable. So this would be similar to holding, the universities responsible. It's not that I'm asking students to be notified whether or not there's a bad recruiter coming in. I don't believe in notification, so as a useful tool. This would be more of saying the Washington Post is actually responsible for the 53 trackers and whatever they did with it, because they invited them in to track. So, I agree with you. The feasibility of it going through federally, I have no. Yeah, I agree with that piece of it. But I just want to be clear, I don't actually like notification, and I don't think that works very well.
So,
and that was the sorry, Dean.
No,
I'm
go ahead.
going to come back. The second half of what I wanted to say, I forgot because I'd gone on for too long on the first half, which is this. You're right, it's just notification. The UK is experimenting with going further and talking about if you have data, you have a duty of care to the data subjects in respect of that data in all sorts of ways. And it's an incredibly badly drafted piece of legislation, again, because the state wants a power grab, and you've got all sorts of lobby pushback. So the second half, we work out what's happening, and then we make. I'm surprised the Washington Post is only 57 trackers. 57 trackers, and there's nothing on to rework the old thing about TV channels. The conceptualizing how you make them responsible is very hard in legal terms. The duty of care proposal by the UK government is just messy and it's overbroad. I can see how you make corporations responsible for climate issues, but that took a while. And I think that we've got to take the same while now to impose the same kinds of responsibilities and liabilities. It's just not going to be easy. Sorry, I should have said that and I had forgotten. So thanks for your...
Couple quick brief points. One, no matter what happens, it's going to be different all over the world. Governments are not going to cede their view of what will happen here to individual choice. I'll just state that as a fact and defend it if anyone disagrees. Two, Mark, to your point on the clash, what is there an incentive, et cetera? I think my short answer to that's pretty simple. If you're a data company, no. I go back to my third or fourth and fifth bullets on my just basic propositions that I always start with. The incentives to track are high. The more you can track, the more effective your business will be if you're in the data business. And I really don't see that fundamentally changing, and I don't see the anonymity issue being gone. Will there, third point and final point, be something done about that? I think what you're seeing start to emerge is for those who are not so much in the data business, but in the, we'll call it the hardware business or equipment business or other businesses, they're seeing an opportunity there that they make it more difficult, at least via a discrete set of devices, to do that sort of thing on their device. And you can already see the clash starting between the companies that survive on data and the companies that survive on selling you a phone or something else, where that's where their primary revenue comes. And we're going to watch that play out over the next few years. And my bet is that it's going to be a pretty intense fight.
Yeah, that's great. So just to be clear, so I agree about the lack of real market sort of tuning solutions here. I just think the reason I think that's important is I think that the whole idea that all we need here is notice and choice has been driven by the idea that we can get the market mechanism to work right if we just get consumers the kinds of information. I think that's been an abject failure. And so I think sort of recognizing that we need actual regulation that goes to the data flows themselves and not just to information about the data flows, I think is really critical. So there's a lot of questions coming in, which is great. I'm gonna try to bunch two of them, which I think are basically the same question. Several of you guys talked about the fine line. I think Dean, you mentioned it this way too, the fine line between whether it's a private entity or the state who's gathering. And so one example of that that's come in through through some of the questions here is thinking about companies that are actually very closely aligned with certain states. So companies like TikTok or any of the Chinese companies, right? So just as an anecdote there, but I should say, though people sort of talk about that, it's not totally obvious to me that we should think that radically differently about companies in the United States. One reason for which is we saw especially during the sort of initial stages of the NSA thing, lots of American companies are pretty eager to hand the data over to the US government as well, and have been doing that pretty regularly. Just as an anecdote about that, I was for years telling my kids, like, please don't use TikTok. And I was telling them about the relationship with the Chinese government. And 201, they all were like, you think that's any different in the United States? And I was like, no. So that's one version of the story, right? Which is that there are companies that are sometimes not that distant from the state. And so if you're worried about sort of state access to information, there's another version of it, which also I think came out in the NSA, which is that, like, especially when there are major players who have huge amounts of information, boy, is that a flashing red light for a government that wants the information, right? It's just a beacon for them to go get it. And as Deen, you mentioned, is a lot of that's gettable through legal process in a particular way. And so maybe, the sort of juxtaposition of like state action and surveillance and private action really just isn't a hugely meaningful distinction in lots of ways once we start thinking in the aggregate and the information. So I don't know if any of you had a reaction to that, but that came in a couple of the different kinds of questions here.
I stated my view. It's a really fine line. And I have seen one example after another in private practice dealing with these issues. Corporations, by definition, and I don't mean that in a negative way, are highly incentivized to cooperate with the states in which they operate. They're a function of the rules and regulations of those different states. And if they operate on a multinational basis, they're just as incentivized to cooperate with the different standards that those states have. And without picking anybody, I think others can highlight where there's been a variable standard depending on which state they're operating in. Probably a good point for me also to just note here, as a practitioner speaking purely for myself, this whole seminar and not either for my law firm or for our clients in this area, which have a variety of interests, over my good colleagues.
Yeah, I just that's a good reminder. Yeah, so I just think it makes it, when we think about surveillance, instead of thinking about it as an either or, state or private, it's more like an and, I think.
Yeah. And you don't even have to be aligned. Again, I'll go back to my 7th proposition, where a day after day after day, if you've got legal process, you can follow that legal process. In some countries in the world, legal process is a very short thing that requires a call from the right official. And we have clients that deal with that all the time, and they have to manage to that world. But if we want to take what in some ways is a high water mark, I won't define the high water mark, but the legal process necessary in democracies like the United States, it's not that difficult as long as you have the right need and as long as you check the necessary boxes in the process. And the notion of 20 years ago that the data might be around for a day, but it was stale after a week and something had replaced it, that's no longer the case. I can go back and find lots of things over an extended period of time because it just doesn't cost that much anymore to make data permanent.
And even if you're the state, you don't actually need there will be circumstances where you don't actually need state process. Yes, the state can apply for a subpoena or whatever. Sometimes it can just simply go out and buy the data. All those people that the data is being shared with, the 57 other brokers behind the Washington Post, or the company that Mark was talking about, or the entire shadow market for data. The state can buy, and when the state does buy, it gets kind of creepy, but we don't really know how to describe why it's creepy. There are, lots of ways the state can engage with corporations. 23andMe and other DNA sites have been used by law enforcement to track down track down people who left DNA at crime scenes. And okay, it's great, it's wonderful, it's very creative, it's wonderful lateral thinking, but it's also a bit creepy. That the data is there so that I can find out that I'm 10% Viking or whatever. And, you know, the 60 million Americans who claim that they've got at least 1% Irish, they can go to 23andMe and find out. But the state can also find out where I was, not just by virtue of purchasing my location tracking data, but also by simply plugging into these kinds of websites. So when the state wants to act as a commercial actor, it can just buy the data, which I find disturbing. But I don't. This is back to my earlier point. I just don't have the language to explain why I find it disturbing.
Just to say that I have way more than 1% Irish, I just want to say. But actually, on to that exact point, I got interviewed by the local news here a couple of years ago, and it was exactly on the point you just made about 23andMe. They had solved a local murder, a stale case from years ago, and the way they had done it was, so I think most people who give their information to 23andMe and those companies don't realize what I'm about to say, is that there's a company out there that exists that what it does is it aggregates all of the data from all of the companies like 23andMe that collect that information. And then they turn around and sell it to the government. So that in fact, their biggest client is the FBI, and then a bunch of other state and local governments. So, you know, the FBI's got a fingerprint database, but now they also actually have access to this other one, which was entirely privately gathered, but then some private entity aggregated it and turned around and sold it to the government. And the interviewer was like, "Can they do that?" And I was like, I think so. Yeah, like I guess they can. I mean, if there's obviously the question of whether the people who were giving their information to 23andMe, whether that was disclosed to them, that might happen. But surely the answer is it was buried in text in some privacy policy, and so they could. Yeah.
And so that's the virtuous example I want to say, where they go and buy or get. I'll just again say lots and lots of direct, personally observed examples. If a government wants your data, generally speaking, they can go take it without needing to purchase it or whatever.
Yeah, but if they go to take it, they need to show due process. They need to get a warrant or a subpoena or whatever. You know, if you just have a wiretap that's observing the data, that's if you're the NSA, that's the kind of naughtiness that you know, caused the international transatlantic data flows to fall. So at least when you have warrants and remedies, you've got some sort of public control. But you know, if they're just taking it, that's very naughty. And if they're buying it and you don't know it, like Mark, that's creepy. Yeah,
and I'm in the United States, I agree with you. Some element of legal process is needed. I guess my comment is more, as we were talking internationally earlier, legal process is a variable thing around the world. And in some instances, it requires nothing than an individual authorization, and you're off to the races. And if you want the data, you're going to go get it. And many individuals and corporations have been the recipient of what effectively is theft of their data on that basis. You just have to assume it happens.
Absolutely. I completely agree.
Back to you, Mark. Sorry for the discourse.
Oh, that's great. So there's a bunch of questions in here that are, which I'm going to summarize as basically like, do we make progress on thinking about this kind of surveillance by shifting from a sort of US-centric privacy way of thinking about it to a more European-centric data protection, or thinking about it? Is that way of thinking meaningfully different, and does it help us make progress on thinking about what the regulatory responses should be to these kinds of issues?
That's probably for me. Data protection as a concept grew out of privacy, in the same way that 4 privacy torts grew out of a single notion in the US. So you have Warren and Brandeis in 110 years ago, and then in 1960 you have 4 privacy torts. In the same way, you have privacy ideals in the 60s giving rise to data protection ideals in the 70s and international treaties in the 80s, which then lead to the directive and the General Data Protection Regulation. And the European Court of Justice, the highest court in the European Union, has distinguished between individual privacy rights and individual right to the protection of data. So we do make that philosophical distinction. The reason is that for the reasons that I was explaining earlier, that sometimes if you take the privacy language, it isn't always properly adapted to data situations. So by thinking in data protection terms, you are forcing the move, and that makes more intellectual sense. The problem is that that's as far as the Court of Justice has gone. There is a difference. Some things are privacy, some things are data protection. And it hasn't gone any further to say that the consequence, therefore, is that we have to do different things on the privacy side, on the data side, apart from the practical things in the data protection regulation. So yes, the questioner is absolutely right. It's an important distinction, but we're only just beginning to work out what that distinction actually means.
So
I wonder, I'm sorry,
I was
Kirsten,
just going to say, I think that I think in the US we are very consumer focused. So that's why we talk about individuals and their relationship with companies, and individuals' right to privacy, because a lot of our tools are based on a consumer interacting with a company and regulating that exchange. I think the power of focusing on data encapsulates more of the wrongs that are occurring that we in the US don't have even a mental framework to deal with. So just all the data aggregators and data brokers and ad networks and that whole data ecosystem, there's not one consumer relationship amongst all of those. So the FTC and all of our regulatory power really struggles, and even our mindset struggles with, well, how do we regulate or think about regulating a data broker who has information about us, but we don't have a relationship with them? And so we just, and that we're not really very good at even talking about in the United States. Whereas when you're focused on data, that's easy. It's a data subject. You have information about the subject. And so you have certain responsibilities about it. Other things like the use of facial recognition for hiring, where does that come in? Like there's no consumer there. The consumer was actually the company that's going to use the facial recognition for hiring. So if you have a data focus, then you would all of a sudden bring in the candidates are considered kind of stakeholders to the process, and they need to know what type of data is being gathered about them and how will it be used. So I think that in being so consumer focused, which because we're market focused here in the United States, allows us to identify some wrongs, but it really gives us a huge blind spot to a lot of things that are going on that we not only struggle with regulating, but we have trouble thinking about how we ever could, because we just don't have that framework. So I do think that that's an important move for us to get more comfortable talking about data subjects, data controllers, using that type of language so that here in the United States, we stop talking about consumers. I mean, small things like I try not to use the word consumer in my papers because sometimes they're not consumers, they're individuals, and we need to start talking about the rights and the interests of those individuals that don't have a consumer relationship. So it's a great question, and I think it actually leaves the United States kind of behind in talking about it.
The consequence, the CPAA, one of those being the word privacy. We talk about a Federal Privacy Act. All of the major pieces of legislation, is Virginia the most recent one, have the word privacy in the title, not data protection. There seems to be an allergy to moving beyond the privacy paradigm here. And even though a lot of the language is inspired, it's not going far enough. If you see all these other harms, if you see all these other problems, and if data protection is the solution, then name it properly. Don't smuggle it in.
Deen, I wonder if from your perspective, when you're giving clients advice at operating in international things, does it affect the way you counsel them about how they should behave, whether they're working under a regime that's sort of privacy focused versus data protection focused?
Short answer would be yes. And again, the variance itself is difficult for many multinationals and many very well-intentioned multinationals, because you've got to manage the different standards. You're going to have a cost associated from the, I'll call it the corporate standpoint. This is a compliance-based world. There's no opportunity per se. There's only cost associated when you generally think of compliance from a corporate standpoint, and they've got to go to a variable universe. The other difficulty that they encounter, demonstrating some sympathy for that side too, and trying to help people navigate that, is the imprecision. Many times governments have a goal, and the way that goal is implemented, like many corporate goals, is done in an imperfect way. And so the ability to even do something becomes an issue in some instances. And in other instances, you're just going to tell folks, you know what, your decision here is you're either going to engage in this universe on these terms, or you ought to make the business decision to walk away from it. And again, there, candidly, that's an interesting thing to watch too from a privacy standpoint, because in some instances, companies look at the state of affairs in given countries or in given regions and say, by the time I'm done with this type of compliance, or whatever value this type of compliance represents, I'm not interested in endorsing that value, and they move on or move away as a function of that. And again, our scholars here are going to know more about that than me, but I'll be interested to see how that evolves as states get more explicit in the coming years on their objectives in this area. Because I don't, in my experience, they see very little, and that's likely to increase in terms of oversight rather than decrease going forward.
Yeah, that does seem, at least my impression as well, is that interesting is like there was this momentum, or at least there were a number of people pushing in the direction of federal privacy regulation. That seems to now be stymied because there's sort of such deep disagreement about a couple of major things. And so what's instead happening now is a bunch of different states all sort of coming forward. And yeah, it's been my impression, especially anytime I talk to anybody in any of those states, none of them have the sense that what they want to do is stand down and let one of the other states decide that it's going to become the standard. They want to be the standard, or they want to have their own regulations. And so I think what we're going to see is a proliferation of those across the US.
Yeah. And if you're I won't single out again any particular state, but there are a lot of states in the world where the preservation of the state is far more important than an individual's sense of identity, sense of privacy, sense of protection, et cetera. The ability to do all the things that we're talking about today and that we've characterized as the quote unquote bad is in their eyes a good that maintains the status quo. And anybody who gets on a plane and goes to some of those states understands that pretty intuitively, not just as an intellectual matter. And you've got to factor that into the bigger picture, because there's not going to be one big free world where we divine a uniform standard and everybody walks down that road.
Yeah.
At least in my view.
That kind of dovetails to another question that a couple of people have asked, which is to what extent these problems are really problems about industry concentration, right? Which is, we have some really big players in a couple of different spaces. And I'm curious what you guys think about this, because I have myself sort of mixed feelings about it, right? That would we be better off if the government were to bring an antitrust case that would break Facebook apart, or that would break Google into different pieces? Would that make meaningful progress on any of this, or would that just create a whole bunch of additional entities who all now also have your data, and now you have to figure out how to regulate even bigger number of people?
I can go. I mean, I worry about Facebook almost like I would worry about a bad television channel and the ability to target people. I don't know, given the sheer volume of third-party commercial data aggregators and trackers and ad networks and companies that want to manipulate and use that system, they're so dispersed and not concentrated that if we broke up Facebook, it would be one place where people can gather and be targeted. But you know, a lot of the companies that Eoin and Deen have mentioned that are being, you know, where law enforcement is asking for their data is not Facebook. You know what I mean? Like they're kind of hidden in behind the scenes. So I do worry about them, but I think almost they gather so much attention. Then we have this whole data ecosystem that's doing the same thing, only more, and it's hidden. You know what I mean? So I'm not sure that breaking Facebook could solve other problems. I'm not sure it's going to solve the surveillance problem that we have.
I think it's necessary, but I don't think it is by any means sufficient to bring that kind of market response, or sorry, a state response to the market to bear. I take Mark's point at the end that you know, you make Facebook into 6. Now you've got 6 companies that have all the data rather than one company that has all the data. It's different to breaking up AT&T. Where you divided it into regions and one company had the wires, but they didn't have the wires in the other region. Whereas here, everybody has all the wires all the time. So there are some issues that structural remedies will deal with, but it's simplistic. It's easy. You know, a lot of the remedies here are simple and wrong. The real remedies are difficult. And so you've got to do an awful lot more to address market failure than merely break up Facebook. The real problem is the nature of the data market and the data brokers behind, as Kirsten says. One of the scary things, I remember when the last administration transitioned in, the White House took down a very useful report that the previous administration, again, the Obama administration, had done on the nature of the data brokerage market. And that disappeared from the White House website. On the other hand, you know, there are lots of mirrors, but it just showed that the market doesn't want to admit that this is what it's doing. All the things that Kirsten has described are the sort of the dirty little secrets that they want to keep hidden.
All right, so we're coming into the home stretch here. So I want to ask a couple of questions that people sent in, which are basically, well, there's kind of two of them, so I'll do them one at a time, which is to what extent has the pandemic worsened the problem, right? Meaning that, you know, some of the proposed kind of technological tools for tracking and tracing, or, you know, other kinds of, like, to what extent have the circumstances of the world given us reason to do more surveillance? And then the second part of it, which is basically, we see this pattern a lot where certain kinds of surveillance tools get accepted for certain kinds of reasons, and then the reasons go away, but the surveillance tools don't, right? They stick around forever. Is that likely to happen here? I guess I'll just stop there.
2 quick answers on my part. On your second one, useful data generally doesn't go away. So there's my kind of direct view on that one. On the first one, again, from my own perspective, and my colleagues may disagree with me, pretty straightforward answer, which is much more of life has been driven online in the last year, just writ large, in all sorts of different ways. So doing this video conference right now, rather than sitting around a table and having a drink afterwards. And to the degree anything goes online, the ability to save it, track it, do other things with it, individualize it, aggregate it, et cetera, increases. And so if anything, the pandemic has gotten folks more used to using mediums that will result in less privacy overall.
It has certainly accelerated an existing trend, but it has not just accelerated it, I think it has supercharged it. So everything is happening online. There's an awful lot more data. There's an awful lot more medical data. There's an awful lot more individual data. There's, as you say, tracker apps. So yeah, there's an awful lot more data online, and all the problems and all the temptations that go with that. Two anecdotes. Anecdote one, the way in which the Ontario government had set up its tracing app, the Ontario police just decided, well, they didn't like what Deen was doing, so they decided to go into the data from the tracking app relating to Deen to see whether he was talking with Kirsten, who is a known person of interest, without any legislative basis. The data was there, they just went and did it. Singapore changed the legislation so that originally it was only for health reasons, and then it went over to law enforcement reasons. So the question about will the methods of surveillance continue even after the reason for the surveillance is gone? The answer is yes. Mission creep is inevitable. And you might get it, unofficially like in Toronto. You might get it officially like in Singapore. But it's simply just going to happen. It's a function of governmental nature.
I think the second thing that it's done is it's provided a validation for some of the bad tracking behavior. So specifically, in addition to what Eoin and Deen said, there's similar to the idea of like location data aggregators, and there was a location data aggregator that provided aggregated data. So at like a general area level, and nothing about an individual. So nothing was identifiable. And they actually partnered with different cities to say, this is how mobility has been working in your area, just to be able to track, we all saw these maps, which states are being better about mobility and moving around during COVID, like last summer and last fall. And so, but the same data aggregator could then have news stories about it, how its data is so helpful. But the fact is that it regularly sells data at a very individualized level. So it doesn't actually sell it in an aggregated way. So the news story was great. And it was all like, we have non-identifiable information and we're helping you during your pandemic. But the fact is that what they actually did on the other side of things on their regular business was selling individualized data so that people could be tracked based on where they are and who they're with. And so I think it gives this veneer of acceptability on some of these practices, even when it's not the same practice, but it's still using the same type of data. And that's a mistake, that we should think that, okay, then we need to let location data aggregators do their thing and tracking has to happen, because what if we have another pandemic? But the fact is, there could be better ways to do this where we don't actually have to have individualized data being used to target people. But that's a problem. And that happened after our insurrection on January 6th, where they could identify people from location data aggregators. It doesn't make everything else that they do fine. It's just that anytime we have some sort of national security issue, we look to devices that then all of a sudden have this legitimizing effect on those devices.
You might remember that the New York Times had this infographic last year in the spring, like it might have been in March, and the infographic basically allowed you to see how people from a specific beach in Florida had then carried the virus around the United States, right? So they basically could follow individual people and show kind of like where they went. And they were using it to show how, just one little location can wind up having this huge effect. And I was looking at it thinking, where in the world did they get that data, right? Yeah, and the answer is they had location data on every one of those phones, and they just tracked where all of it went. So, yeah. There's also,
ironically, that was a hotel on the beach that had a medical conference.
Oh my gosh. Well,
so it was, it was medics and doctors and so on who'd gone to Florida for a conference and then got it and brought it back to everywhere else.
Yeah, wow. There's one other dimension to it too. I don't know whether any of you saw this, but there was an article just this week in the Chronicle of Higher Education, and it was about the surveillance tools that universities have deployed now against their students. In many cases, at least nominally, sort of for good purposes, to try to track their physical and mental health, but in some cases to monitor whether they're cheating on their exams or things like that. And it was making the same point that these tools won't go away when the pandemic is over. These are going to be sort of institutionalized. So just to add one more layer to it, that they won't go away, I think what it's also done is now there are other actors, right, who you wouldn't have thought of as being engaged in these kind of surveillance practices, who it's now been normalized for. So not just the practices, but now the sort of universe of places where that's going to happen to you may be growing. I suspect this is true for many employers as well.
Yeah, you're again, I'm kind of back to my 7 basics. The incentives there, so I think that's the case both on the employer side and on other sides. And I'll since again, not to be negative, but you charged us with identifying the challenging. We've modified the bad to the challenging. I'll add, never discount the prospect of an accident. There's lots of this sort of data that's gathered. There's a perfectly good policy associated with it. We will use it just for this purpose. We will delete it after this number of days, etc. Anytime you put human beings in that process, it's fallible, and they don't necessarily do what the process provides for. And again, you're in a scenario where I've lost track of the number of clients where you look and say, why in the world was that piece of data here where somebody could take it? And the answer isn't some complex, nefarious purpose, or they had this master plan. The answer is somebody forgot to delete it according to the policy, and it created the problem. And the more we have online, the more we need to deal with that world as well.
This is a point I make all the time to my students when I'm teaching privacy, is you teach these classes that are basically about responsibility for data breaches, and you always expect them to be these super sophisticated technical hacks. Yeah. And instead it's like somebody leaves a laptop with a spreadsheet open in the back of their car, right? And then it's got all kinds of data in it or something. So yeah, there's tons of low-hanging fruit in that respect, right? Lots of people who just make mistakes that you can't believe. So
if I take 10
that universities would have to worry about is that they'd be just like hospitals. They might not have data that people want to use. I mean, they could, but they definitely want data that they want to protect, meaning ransomware attacks. And so they would be a prime target that they need to maintain the trust of everyone around them. Their data might be valuable, but it might not. Like leaving aside like the engineering work and the national security stuff that big universities do. But could you imagine if it got out that there was a ransomware attack against a university, and how all the parents that wanted to have kids there, would be so upset by that type of breach? And so anytime that universities carry around more and more student data, like location data, healthcare data, it's just a honeypot for people that want to make money off of it, whether they're going to take it and sell it or hold it hostage. So it's, I remember Carnegie Mellon actually put forward putting Fitbits on their students, because they wanted to track them. This is a few years ago before the pandemic. And I remember talking to some of the privacy scholars there, because they were on the board thinking about it. To this point, they weren't sure what was going to happen to the data afterwards. My question was, what type of barriers are you going to have to like an FBI agent that wants it? So are you going to say no? Or are you going to, because that could make the students feel very surveilled if, their answer was no one at Carnegie Mellon does anything illegal. So, which I said,
sure, yeah.
I said I would not count on that.
That's reassuring, yeah. So,
I've represented several universities in large data breaches, and I'll just say there is a lot of global interest in the data that universities hold.
Yeah, I would especially financial aid data, I would imagine, would be pretty attractive, right? So. All right, well, we're basically out of time. I just want to end by thanking all of you guys that was a really great discussion. I appreciate all the insights, and even though we were focused on the bad, I think we got a lot of interesting thoughts about possible progress on solutions too. So thank you all for joining us. I hope you can stick around for some of the rest of the symposium, but otherwise we'll catch up with you next time, Eoin, hopefully in person.
Looking forward to it. Thanks very much. I thoroughly enjoyed it. Took loads of notes. I'm going to steal all your ideas for class next week.
Great.
Thank you.
Take care, everybody.
Bye-bye.